Sorry about that. Hey, Ruby, what's the date on this thing that is showing? Because I don't know. It has it like tomorrow, right? Is it showing tomorrow? I don't know what I did. I don't know how I ended up showing it the wrong date. I don't know. I tell you, it's always something with me. It says August 31st. Okay. But I was trying to figure out why my thing didn't show like I'm supposed to be on. All right, y'all, let's go. Let's go start watching this. Hey, Trissy. Hey, Joanna. Thank you, guys. All right, let's go. Let's go show you guys some stuff. Okay. Today was a very, 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 very interesting day. Okay. The reason why hold on a second. I got a call. Hold on a second. Just 1 second. My apologies, good people. My apologies. Okay. The reason why I titled this why, I'm gonna start from the end and then I'm gonna bring you back to the beginning, okay? But I'm gonna show you something, y'all. I'm gonna show you in this individual, guys, and I know a couple of you guys have seen this guy at court, and you're probably wondering what is up with this dude? What is up with him? But I'm gonna show you. Okay. I'm gonna share this with you guys for a second. And then I got to show you something else. Just bear with me, okay? All
right. We will be conducting jury selection, continuing with the examination of our jurors, starting at 9 o'clock, and we'll go to approximately about 11:30 or before or sooner if we clear that. And just to let you know, Ms. Von Kelsch, as of right now, has lined up for tomorrow. Of course, confirmation waiting. Jurors 295, 301, and 303. 295, 301, and 303. That is the voir dire lineup, potential voir dire lineup for tomorrow. All right, are there any ministerial inquiry of me at this point in time?
Your Honor, there is one item that states on administrative question.
Can you ask it in front of everybody or what?
Sure.
Okay, go ahead.
It's to do with transcript of the April 20 hearing that I bear a message from Mr. Can you microphone, please? Microphone. Your Honor, we were going to ask on behalf of Mr. John Floyd about whether the transcript for the April 20 motion that he argued, whether that was available. Mr. Floyd, I guess, needs it to prepare his order.
You buying sandwiches from Anton Samora. Don't come without them or else. Don't want to hear it. Your colleagues want Anton's.
Can I get something other than sandwiches?
What'd you have in mind?
You know what I
I don't want to hear about your extracurricular activities, okay? As entertaining as they may be. All right. Miss Weaver's going to double check, but she believes that task has already been done, sir.
Thank you, Your Honor.
Okay. Anything else?
Real quick, Your Honor. I know this is way in advance for the court, but September 15th and September 25th are religious holidays. I don't know if you're planning on having court that day. If you are, it would be good if we could get a little notice so that we can make alternate arrangements.
Yeah, I want you guys to take a look at Mr. Darcy over there. That guy that's sitting next to
Deshaun, is that
Jimenez.
correct?
Yes, Your Honor. Yes.
Okay, is there a particular time you need to be out of court by?
On Rosh Hashanah? That's Rosh Hashanah Eve, so ideally 2 o'clock, 3 o'clock.
I think we can accommodate you because that date I have Veterans Court in the morning, and I think that I'm taking status on your colleague, Mr. Johnson's warrant. I mean, the search warrant, and that's the only thing I'm doing that day.
Okay, thank you, Your
I
Honor.
feel pretty comfortable that I should be able to get you out of there. What's the other date that you have in mind?
The 25th, Your Honor.
That's Yom Kippur.
Yes, Your Honor.
Yeah, look at how he's moving. The guy over there next to the attorney. Look at him. Keep an eye on him. The one with the glasses over there. You see him? Hey, Laura. You see him? The guy over there with the glasses that's with next to Jimenez. Just keep watching him, right? He never sits still. He's constantly moving.
Okay. I suspect, sir, that I will probably honor
Just keep
that
an eye on
request,
him,
okay?
y'all. Just keep
Thank
an
you
eye
very
on
much,
him.
Your Honor.
Look at him. He keep
Anybody
moving,
else?
right? Look at him.
No,
Look.
just some guidance.
Look,
as to
look
next
what?
week. I do know that I have to report back on the 6th at 9 a.m. upstairs.
Look at him, y'all.
And I'm thinking it's gonna run into Thursday. I doubt it's gonna run into Friday, but does that mean that there'll be more motions in our absence or just off days?
I was gonna wait and find out what you're
constantly moving.
doing.
Just keep
I
watch
think
him,
the last
y'all.
day that I
Watch.
can I have some say will be September the 5th when we deal with the contempt issue juror, alleged contempt issue juror 25 and jury selection. So on the 6th, I will more than likely take status on some things that we have outstanding that your colleagues have indicated. For
Y'all see,
example,
he moving, right? Constantly moving. Just keep watching him, y'all. Watch when the judge asks him a question.
there are a number of motions that Mr. Adams and Mr. Steele have filed on behalf of Mr. Williams that that should be satisfied, or they're to update me on that. So I will probably take some time on the 6th to do that. So I don't believe you'll, if your intent to still, you and your client for the continue to waive that, or tell me what your pleasure is. But that's what I plan on doing, and just waiting and see what happens with your other matter.
Tim and I, I waive my presence and my client's first waiving our presence. We are confident that those motions will be handled adequately, and if there's any issues, we ask legal to go any.
Look at him, y'all. Look at him.
After we
Okay.
get a chance to review the transcripts.
Look at him, y'all.
Mr. Dorsey, are you in concurrence, sir?
Look at him. Look.
Could you make an audible response just so I know you can?
Look at him.
That's a nonverbal response. Can you make an audible response for me, sir?
Look at him, y'all. Look at him. Look at him. Look at him. Look at him. Look at him, y'all. Look.
You know, we might have to take up an issue once we're done, once we come back out.
Say again?
We might have to bring up an issue once we get back next week. At this point.
Look at him, y'all. Look at him.
The way things have turned, maybe I might need the courtroom.
Wait, he's gonna get closer. Look. Look at him, y'all.
I'll deal with that accordingly, but your client, I noticed, has been doing the same behavior, and I believe Judge Adams inquired into it as well. So I don't believe that he may be doing it just for the purposes of just drawing attention to himself. But of course, sir, as you are well aware, I'm duty bound to consider whatever it is you want to tell me. But your client's nodded in affirmance. He just has some extra movements that the court is noticing, and he's done that the entirety of this particular proceeding. So you haven't said anything up to this point in time, so I'm going to assume that that's something that you and he are working through.
Yeah, and then on Tuesday, what time are we going to do?
9 o'clock, yeah, let's see. Hold on, wait 1 second. Tuesday the 6th? The 5th? Oh, I'm sorry, sir. I apologize.
Wait. I have, hold on. I'm gonna pause here for a second. I want to show you something else. Hold on.
Okay.
I'm gonna pause him for a second. I want to show you something else with him. Hold on. Thank you, Laura. We gotta play the music for Laura. Hold on. I got something else to show y'all. Hold on. Let me play my music. Okay. I'm gonna show you something else. Okay. The other day, because he's going through a trial right now, a murder trial, right? The other day he had a hearing with Judge Manning, right? I'm going to show you what happened at that hearing. This guy is a lot of extra going on with him. Hold on a second. I'm going to show you something. And then I'm going to go back to our hold on a second. Hold on. Okay. Hold on. Okay, this is him at his hearing. Hold on, y'all. I'm gonna show you this. Okay, watch this here. All right, watch this. Hold on. This is him at his hearing here. Play this for y'all. Look at him, y'all. Look at him. Look at him. Look at him.
No.
You good?
It's a show, Judge.
Oh, it is?
Yes.
Okay, well, I ain't Judge Glamble, and I don't play, so stop showing out. All right, let's see. Mr. Jimenez, you want to tell your client to get a grip on himself? Mr. Jimenez.
Look at him.
You want to tell your client to behave?
Your Honor, I've been struggling with the movements myself, but I think he's just nervous. He does that when he's nervous.
All right, that's fine. He wants to act like that, he can. All right, so we got 23, CP 218152. Cordelius Dorsey, 253 days without indictment, not on this charge. This is a new charge. And it looks like there is one count of aggravated assault and one count of riot at a penal institution. Deputy, if you raise your right hand, you swear affirm testimony about the is the truth, whole truth, nothing but the truth.
Yes, ma'am.
Can you speak up a little bit in the microphone? Just state your name and spell it. Go ahead.
I do.
Yeah, state your name, spell it for me. You can put your hand down.
Okay.
Go ahead.
You want my full name?
Well, I mean, just first, last, you know. What's your
Nicole
first
Paul,
name?
Nicole. Last name Paul, Paul.
All right. Go ahead. What says the state?
Thank you, Your Honor. Deputy Paul, how you doing?
Good. How are you?
I'm fine, thank you. Where did you work this week?
I work at the Fulton County Jail. That's 901 Bright Street.
And and that obviously is in Fulton County, is that correct?
Correct.
All right, and I'd like to direct your attention to the evening of April the 29th. Was there an incident that occurred at the jail?
That is correct.
And did that incident cause you to pull some warrants?
It is.
And can you please explain to the court why you did so?
I did because the assault was very severe. It was a stabbing on the floor, and multiple inmates were involved.
Okay. Okay, so let me back you up. How did you come to be at the scene of the stabbing?
I was reassigned to the floor. That floor, I believe, was 5 North at the time. I was assisting another officer when we heard commotion and got a call from the tower officer that there was an incident occurring in the zone.
Okay, and so how long before you arrived? Once you got the call, how long was it before you arrived?
Maybe like a minute or so. Mm-hmm.
Okay, and when you arrived there, explain to the court what it is that you saw.
Once I arrived at the door, I saw 2 inmates. One was bleeding from the head and another was bleeding from the arm. We opened the door. I called for assistance. Another officer came to assist.
Okay, and did you have an opportunity to investigate the incident?
We pulled both inmates out of the zone. At that time, they pretty much told us exactly what happened.
Okay, and can you relate to the court what it is that did happen or what they told you happened?
Both inmates claimed that they were jumped by the defendants, which was 4 of them at the time. Ballard, Marcus, Dorsey, Cordarius, Longio, Cameron, and a Price Monte.
Okay, I just wanted to show you guys what he was doing at the hearing that he had this week with Judge Manning, and I was showing you guys that he does that all the time. Do you guys remember of several videos? He has a headset on and he's constantly moving, and people would always ask, "What's wrong with him?" This dude act like that all the time. Here's the thing with him. The reason I say something is really up with him. There's a video of him. I think allegedly, there's a video of him committing a murder. It's supposed to be 2 murders that allegedly he has committed. So that's why he's going to trial. And then since he's been arrested, he's going to be spending the rest of his life in jail because he's on life a life prison term already on a case before. But I believe this is Sylvia's opinion here, not facts or whatever. And I think they definitely need to get him evaluated because the stuff that he's doing, that's not normal. It's really not normal. So I don't understand why he hasn't been evaluated. Because remember, you guys, they have had 4 murders death, not murders, death in Fulton County Prison. There's quite a few people in there who have mental illness that they're not dealing with, and they thinking that these people are faking. You know what I'm saying? They got a lot of mental illness in there. Remember the guy they saw with all the bed bugs? You know, his head was found in a toilet bowl. And the reason why they had him down there, they never went to see him because he had mental illness. I don't think they're equipped to take care of some of these people in there. They just throwing them in there with everybody else and not understanding that these people have mental illness. Some of them need to be medicated. And then now you see how the other guy that was in the same case, remember the one that used to stare into space? Remember the other one? They got him severed off the case. Remember how he used to act, staring into space? Well, this one, I watch him. I watch this one all the time. Whenever I'm like at court, I watch him. He had the headphones on and he just be moving around. I'm gonna show you some old footage. You guys gonna agree with me. Every single time when he put on the headphone, you thinking he listening to music. Half the time he's not even listening to music. He's just moving around like that. There's a lot of mental illness inside that jail, and they treating them like regular people and thinking that they faking because you heard what the officer just told the Judge Manning. Oh, he's acting up. And a lot of them are not equipped professionally to recognize the mental illness that these people have. So I don't understand what's going on, but I don't know. But let me go ahead and finish playing this, the live from today.
Anybody else?
Your Honor,
Yes, Mr. Steele.
I'll put it in writing, I'm going to file a motion to sever if that conduct continues, Mr. Dorsey, because I believe it's going to prejudice Mr. Williams in front of the jury.
You're welcome to file whatever you feel
See, he's
necessary,
asking to
Mr.
file
Steele.
so he could sever
We'll
this
take
guy
that up
from this
accordingly.
case.
Okay. Anybody else? All right. Unless there's any other inquiry of me, then we'll see you all tomorrow morning for a few.
Okay, I'm gonna
People
stop
examine.
this, and I'm gonna
All right.
start.
We're in recess.
I'm gonna start from earlier, so you guys can see what they talked about in regard to the case. I really want to show y'all, because I know a couple of people talked about the worship, the goat worshiping thing. Okay, I'm gonna bring up everything that happened earlier. Okay, I'm gonna go ahead and play this. If you have any questions. Hey, William, how are you? Is he a YSL member? They're supposedly putting everybody in there. Laura, I think it's mental illness. I think it's mental illness because well, I don't know. I'm not a doctor. I don't know. I'm not gonna. I don't know, Laura. I don't know. I don't know. Let me keep my. I don't know. All right, let's go ahead and play this. Y'all block that person. Whoever this person is, block them. Mods, block them. Thank you.
Adams et al. In 22 SC 183572. Let's go ahead and take roll for this morning, the 31st of August.
Hey, Trina.
Of 2023. Okay, so Mr. Partridge and Mr. Beebe, good morning, gentlemen. Mr. Stillwell, Mr. Boss, Mr. Sharp, good morning, gentlemen. Mr. Williams, Mr. Steele, and Mr. Adams, good morning, gentlemen.
Your Honor,
Mr. Kendrick, and let's see, Mr. Weinstein, good morning, gentlemen. All right, Mr. Matthews, let's see, where's Mr. Matthews? Oh, Senior, and Mr. Huey, good morning. Okay, and then let's see, for Mr. Nichols, Mr. Harvey, and Ms. Westmoreland, good morning. And then for Mr. Dorsey, we have Mr. Chada Jimenez, and new to the party, Ms. Diaz. Welcome and good morning. And then Mr. Ryan and Misty Williams. Good morning, Your Honor. Good morning. All right. Okay, counsels for the state. I'm gonna need to leave you all out. Ms. Hilton, Mr. Uhelski, and Ms. Love, good morning. All right, Messrs. Smith and Brown, good morning, gentlemen. All right, and good morning, where's Mr. Randolph? Oh, he's not here yet. Okay, all right. Okay, a couple of just kind of brief housekeeping things. Mr. Chata Jimenez, good morning again, sir. You and your client have another matter, and I understand that you were to be back before Judge Esmond Adams on the 6th of September. Is that correct?
That is correct, Your Honor. We're still in trial. The state rested. We are putting up our case, and my calculations is that it should be done that day. Our case will probably take about an hour.
Okay.
And the jury should get it by the afternoon. So at the most, I am expecting Thursday, hopefully a favorable verdict by Thursday.
Okay, all right. So just keep us posted. We just wanted to kind of get an update on that. And the other thing I wanted to kind of just put on the record, just for formality, you represented on your client's behalf that you were going to waive his presence for the purposes of handling motions that didn't directly relate to you, but given that you are in trial, you said you would waive your client's presence for those because you had other counsel that would update you as to any developments. And I also gave you the opportunity to file any motions or take a look at the transcript should that necessity present itself. Is that correct?
That is correct, Your Honor.
Okay. All right. Since your client's here today, I just wanted to see if Mr. Dorsey, did you have the opportunity to discuss that with Mr. Chata Jimenez?
Wow, Laura, really?
In concurrence. So we had some matters that didn't involve you necessarily directly, but did he give us the right or the correct announcement as to your desire?
Yes, it would just be required to affirmatively or negatively say on the record.
Yes. All right. So, Mr. Dorsey? Yes? You're nodding your head in agreement? Okay. All right. Okay.
Look at him. I'm sorry. I don't mean to laugh. I'm sorry.
Okay, that was the first
Lord,
housekeeping
forgive me,
matter this
please.
morning. Second housekeeping matter is after we
I'm sorry, I don't mean to laugh.
Mr. Steele's on behalf, and Mr. Adams on behalf of Mr. Williams, just motions and some other issues as it relates to them. There's probably about less than.
Please forgive me. T-girl, don't laugh, please. I'm trying not to laugh no more.
I need to circle back, or we need to address. And then for your planning purposes this afternoon, Ms. Von Kelsch has, or I've had her order up 3 jurors to be examined for this afternoon. And these would have been jurors that we're not able to get to. And I want to say that's jurors 288.
You said that's like a drug flock that they do on the streets. That's the way they make people act. Really?
Handle this afternoon starting around 1 o'clock.
For real?
So that's what we're going to do today.
That's it. One drug people need to
morning,
stay away from.
We'll handle, and that is tomorrow.
Drug-induced psychosis.
The 1st of September, we will handle some more jury selection issues or examination from 9 till about 11:30. And that will be our day on tomorrow. And then, of course, the 4th is Labor Day, and on the 5th we have a contempt matter involving juror number 25, and we will handle juror issues the better part of the day. That's our schedule for the next several days. Any questions of me as it relates to that?
What's the start time for September 5th?
That'll be at I'm going to tell you 7:30. That means we'll get started probably about 9 o'clock or thereabouts. That work for you?
It does.
Okay, all right. We're going to start as close to 9:30 as we possibly can, and I do have a couple things I need to take up during the middle of the day.
All right, let me put my thing on.
I will recess accordingly to do that. Okay, all right, anything else, or any other ministerial inquiry of me? Okay, all right, okay, all right, well, let's continue on at this point in time. Mr. Steele, I believe that we left off, at your motion limiting number 20. I believe that motion, you allege that to exclude any and all 911 or CAD calls and then CAD reports until we have a hearing on the admissibility of those calls and or reports. And I believe basically that would be a foundation issue. Is there anything I've kind of missed?
No.
As it relates to motion limiting number 20.
No, Your Honor, and good morning, Your Honor. Good morning
Morning,
to
sir.
everyone. And that was filed on June 28, 2023. What the court said is the import of this motion. And what I also would like, just so we don't have to waste the time of trial in front of the jury, if I can have, and the state could provide, what CAD reports they plan to try to introduce and 911 calls, it would make it a lot easier. And then I could wage objections or no objections to same. But that is exactly what I'm asking.
Okay. Would that fall into, I think that we talked about last week, some at least 72-hour or at least requirement that we at least tell what we're going to present. Would that fall in that category?
I would hope so. Now, I'll leave that up to this honorable court, but I targeted their separate motions. So I targeted charts, documents, recordings. I would like to include the 911 recordings and any CAD reports. That would satisfy me a great deal.
Okay.
So, Your Honor, I'm not responding to the entire motion. Mr. Uhelski will respond to the entire motion, but as it relates to the request that we essentially turn over our trial strategy by giving the list of 911 calls and CAD reports that we intend to use, I would object to being required to do that. We have turned over all the 911 reports and CAD reports that we expect to use, and certainly, you know, they are entitled to that. But I'd ask that the court not require the state to essentially at each juncture tell counsel for the defendants, this is what we expect to use tomorrow. These are the things we're going to use. Now, if there are pictures that have arguably some level of contention to them, those things we don't have a problem doing. And certainly we don't have a problem with the jail calls because there are a million of those. But when we start narrowing that request down to every aspect of the state's case, we believe that that is unduly onerous and that the defendants are not entitled that level of specificity as we proceed with trial.
Okay. Here's what I'll kind of address it this way for both counsels. As you all know, it would be subject to applicable foundation. And as long as those foundational witnesses are ready and be prepared to testify, then I think that you'd probably be all right. Now, there may be other objections, Mr. Steele, that I may have to take up depending upon what is adduced, but or presented. But you know, I think that's just, I would just advise you if there's going to be some contention as to it, early's better. A forewarned judge is a happier judge. And the reason I'm happier is because we'll have our citizens in the box. And what I don't want to do is take them out of the box. I just have to deal with a protracted, lengthy issue when you could have just dealt with that up front. So that's what I'm kind of cautioning you everybody as to, because these jurors need to have whoever's selected as smooth of a presentation as we can provide it for them. So anything we can take up in the pendency, that's fine. I don't think Mr. Steele would love to get your trial strategy or whatever. I'm not requiring for you to do that, but I am gonna just ask you in you all's professional capacity as advocates to let me know sooner rather than later. So if I need to take up something, I can do so, and I can kind of craft it accordingly to keep our jury as potentially as happy as possible, okay?
Yes, Your Honor, and as a matter of professionalism, we certainly will recognize when there are 911 calls that may have information or statements in them that may cause contention. We will bring that to the court and to counsel for the defendant's attention prior to even tendering those types of calls.
Okay, so Mr. Steele, I'm going to reserve that issue, okay?
Yes, can you also, on your notes, also reserve and consider what the Honorable Court said originally, ordering 72-hour notice, because I just don't, I've tried long cases, I've never tried a long case as this, but there is just no reason that anybody here should be trying to surprise somebody and then the jurors just go out for 2 hours at a time. I mean, the rubber has met the road, so I don't see any reason that the state wouldn't want to give over that information, included with their charts, their reports, their other exhibits 24 hours, 72 hours before. So I heard what you said, and I understand you want that to be done, but I'd ask you to also consider further.
And Your Honor, I'd also ask if Mr. Steele has concluded his request to the court, that the court require, since we have turned over all of the 911 calls and reports, that the court will require defendants, counsel for defendants, to specify which ones they have objection to and which ones, which content that they object to. I believe that that would be the more appropriate path to take in terms of motions to exclude.
Remember, they have no burden to prove or present anything.
We don't disagree.
Until that becomes an issue, I'm not gonna require them to do that. I'm not, because
No, I don't mean to suggest that they have to produce anything. I'm saying if there's a motion to exclude or a motion to prohibit or something or limit, since they have everything at this point, if there's something that they object to at this point, letting the state know will allow us to more efficiently and expeditiously handle that matter with the court as well.
Okay, well, if they're gonna file a motion, we'll take it up. Okay, all right, thank you, madam. Okay, all right, the next one is motion to preserve Mr. Williams' right to a fair trial, filed on 6/28.
Listen to this, y'all. Listen to this.
I'll copy that one.
I think this is when they're going to talk about the security situation and the parents being able to be in the courtroom and the family being able to be in the courtroom and things like that.
So, Your Honor, this is a joint motion, and I'm going to ask the Honorable Attorney D. Williams to make a proffer at the appropriate time. But what I've asked is, in this honorable court, the record's clear. This honorable court, and it has said this several times, is nothing but fair, giving a fair trial to everyone. And this is unbelievable circumstances for the court. You also told us that you have a duty to keep everyone here safe and secure and have a good arena to combat and litigate ethically and lawfully. And everyone appreciates that. This motion goes outside of your purview. You may know this already.
Here we go.
When your honorable court comes in the courtroom through its chamber door, we come in through another door leading into the courtroom that the jurors come through. So I am not always here because I come into your courthouse and I do work, so I stand elsewhere. So I'm not really around here, but Ms. D. Williams.
Okay, what's going on here is they're trying to make sure that the potential jurors that are coming in to see, to get examined for hardship or to see if they're going to be seated, They're trying to make sure that they're impartial and not swayed by the stuff that's going on outside the courtroom. What happens is there is a second security screening that is happening in the courtroom, right? There's screening for you when you come into the building, right? And then once they get to the courtroom where the defendants are, where they're doing a YSL trial, there's another screening process, okay? I think that initially it was set there because of situation that was going on in the court. Like they were watching the guy using Johnson's computer, Eppinger. They was watching Eppinger. They was watching a couple of different things. So they decided to start doing a secondary screening process. So their argument is when right outside the courtroom door, they usually have jurors sitting on little chairs right outside the door. When they call them, they come in one at a time. So, but by the doorway, there's a table, and at that table, the deputies, the sheriff department, are searching the attorneys before they go in, searching their bags and stuff like that. So now it's making it seem very prejudicial, because they're saying there's something that the attorneys are doing wrong. Therefore, it's already setting some negative thought towards the attorneys. So what they're asking now is it possible that the jurors not be sitting in that area to make it look like the attorneys are doing something bad? Because if you're searching them and you're not searching the jurors going in, that means there's something going on with the attorneys. So they're trying to keep it where there's no bias, no prejudice, or something thinking that the attorneys are up to something. They don't want that appearance to be shown. So that's what they're arguing about, that jurors are seeing this and they're already setting something in their mind about, there's some danger or whatever. Okay. I want to give you guys a breakdown of what's happening. Okay.
And the Honorable Doug Weinstein, I believe, would be better replica of what goes on outside the courtroom, and specifically in front of jurors that have come into the court. The surroundings, to me, are something I've asked the court to change as we start the trial soon, because Mr. Williams has tremendous, and I'm not saying anyone else does not, I'm confident everyone does.
Okay, the other thing here, he's arguing, that was the first part, because Ms. D. Williams is going to explain everything. The other part he's going to explain is about, how Mr. Williams has not done anything, but he's being treated, and he's asking basically, can that ankle thing that he got on his leg be taken off while he's in the courtroom? And also the security level, for them to dress like regular people, so jurors don't think anything negative, like they're big mobsters and they're gonna shoot everybody up or something's gonna happen, so jurors don't have that prejudice against them. So they're trying to get some leniency of what's happening. But I wanted to take a short look at something else, that the reason why I brought that up, because there is a trial going on where Judge Glanville is the presiding judge over this trial. This trial is about this man who murdered 8 individuals, right? And he did it in 2 different counties, 4 individuals in the county of Fulton County and the other 4 individuals in Cherokee County. And this is it was more racially biased, and also it was more, it's like a hate crime, right? He went in to kill the Asians inside the spa, okay? And I don't remember his name, but anyway, what I'm saying, I'm bringing this one up because I want to show you the clipping of him in court, and I'm gonna show you how he looked in court and how Thug is looking a certain way. They have ankles and all this kind of stuff on them, ankle braces. But this guy, he looks, I mean, he comes in like, I'm just going to show you. Hold on a second. There's a big difference. They make Thug look like a criminal, but this guy looked regular. And and this guy is they're doing a death penalty. He already pleaded guilty for the crimes he done, but they're giving him more respect and more leniency than Thug, and it's just weird. Hold on a second. Let me show you this. Hold on. I'm gonna show you guys. Okay, I'm gonna finish playing hours that we have here, and then I'll bring up the other guy so I can show you what I'm talking about. Hold on. I thought I had his clip up, but I don't have it up. Let me finish playing this for you guys so y'all can see this, and then I'll bring up the guy. Hold on.
Tremendous support here, and they go to a viewing room.
Hold on. Sorry about that. My thing got stuck. Hold on. Okay, it got stuck. Hold on. I apologize. Whenever I do that, it kind of gets stuck, and I have to go woosah for a minute, y'all. Woosah for a second. Just a minute, y'all. Just 1 minute. I apologize. I should have had it. I closed the thing up because I was having a problem. Now I have to try to find it to open it up. Hold on. You heard of that case? Okay. Well, he oh yeah. My bad.
Leading into the courtroom at the jurors come through.
I apologize, y'all. I'm trying to get the thing up for y'all.
The Honorable Attorney D. Williams to make a proffer at the appropriate time. But what I've asked is, in this honorable court, the record's clear. This honorable court, and it has said this several times, is nothing but fair, giving a fair trial to everyone. And this is unbelievable circumstances for the court. You also told us that you have a duty to keep everyone here safe and secure and have a good arena to combat and litigate ethically and lawfully. And everyone appreciates that. This motion goes outside of your purview. You may know this already, but when your honorable court comes in the courtroom, through its chamber door. We come in through another door leading into the courtroom that the jurors come through. So I am not always here because I come into your courthouse and I do work, so I stand elsewhere, so I'm not really around here. But Ms. D. Williams and the Honorable Doug Weinstein, I believe, would be better replica of what goes on outside the courtroom and specifically in front of jurors that have come into the court. The surroundings, to me, are something I've asked the court to change as we start the trial soon, because Mr. Williams has tremendous, and I'm not saying anyone else does not, I'm confident everyone does, tremendous support here. And they go to a viewing room, and I'm told, I've been in that viewing room one time for a short period of time, but I'm told that unless the person is standing, basically where I'm standing here, they cannot see the person speaking. If the microphone's not on, they cannot hear the person speaking. And therefore, I'm not so sure that they are partaking the way that our Constitution allows an open courtroom. And I'd like the court to consider allowing people to come into the courtroom, specifically family members. I understand, and I could describe that the courtroom is filled with people who are on trial, as well as the state. But there should be accommodation made for the media. The media is here. The court always allows the media, from what I could tell, come into the courtroom. In addition to that, I'd like you to, and I know you delegate to the sheriff, but I'd like you to order that the sheriff does not have to put a leg brace on Mr. Williams. He's been wearing a leg brace every day to come in a courtroom. I've never seen him, to my knowledge, he's always nothing but professional and kind to everybody in my presence. And the courtroom is filled, and I shouldn't say filled, but it has several law enforcement officers who've been nothing but respectful, and they're honorable. They're all armed. And if anybody got to the point that they needed interception, there would be sheriff deputies here, as well as, I'm confident, on call. There's also sheriff deputies, to my knowledge, directly outside your courtroom. I believe that when the jury starts, Your Honor, there is a feeling of this is almost such a security risk trial that there's something to fear, and that should not ever occur, and we do not want that to occur. So I would like the courtroom not to have like a fortress-like atmosphere with the law enforcement presence. They could dress differently if your court ordered it, and they could dress as civilians. They could still be armed. But I believe that at this point, this is infringing upon Mr. Williams' right to a fair trial. Your Honor, there's also an issue here about the jurors. I don't know, you move us around, not you, somebody, I don't know who, sheriff deputy, maybe somebody moves us around different tables, and that may be fair, so the same people aren't sitting in the same place. But I'd like to know if that's going to happen during trial. Also, during trial, depending upon where I've sat, I can't always see the witness. There is a monitor in front of the witness face. So I'd like that to be moved as well. Your Honor, there's a case that came out, I thought was interesting. It's CASAS, C-A-S-A-S versus State. And it's 368 Georgia Appeal 434. It was decided June 27th of 2023. And what occurred in that case in Division 2 is the court wrote about that the trial court under OCGA 15-1-3-1 has the power to preserve and enforce the order in its immediate presence as near thereto as is necessary and prevent interruption, disturbance, hindrance to its proceedings. And although it is well settled that a defendant is entitled to a trial free of partiality, which the presence of excessive security measures may create, it is also well established that the use of extraordinary measures to prevent dangerous or disruptive behavior which threatens the conduct of a fair and safe trial is within the discretion of this honorable.
Give me the citation again, Mr. Steele.
It is 368, Georgia Appeal, 434.
You said 368?
368,
Okay.
Georgia Appeal 434. It's in Division 2, Your Honor.
Is the name of the case called what?
CASAS.
434. Sure that's the right citation?
368, Georgia Appeal 434. May I approach, Your Honor?
You can. I just want to see if I got it right. It's not coming. It's coming up with another key. Thank you, Mr. Steele. I've gotten an attorney's site.
So, Your Honor, yeah, I just want, and I know everybody wants the atmosphere to be one of the presumption of innocence. And I do understand that there's, in some cases, tension between needed security, but Mr. Williams has not, to my belief, shown any reason why he is nothing but trusted and not trying to escape and not trying to cause a disturbance whatsoever. Your Honor, with that being said, if it's okay with you, I'd like Ms. D. Williams, Attorney D. Williams, give that proffer because it would be better coming from her than from me because she experienced it much more.
It's going to be regarding the search that happens before we enter the courtroom. So when myself, Attorney Gardner, or Attorney Weinstein appear for court early, jurors are checking in jury services at the desk in front of the courtroom. For example, if court starts at 10 o'clock, we're usually here at 0900. Yes, I'm actually here early.
Because that's part of the challenge that you're creating, is that when you come late, remember, I can't start until all of you are here.
Right.
And every accused is here. But many times, I'm waiting on your colleagues, and you know which ones they are. So what happens is, we have jurors sometimes, and we have you all being screened. If you come on time, that won't be a problem. Now, we have changed this, microphone's got we need a change from what Mr. Randolph has indicated to leave those people down there in their separate, the jurors in their separate area. But if you come on time, I don't think it will be a problem. Plus, I can also ask the sheriff about this issue in regards to the secondary screening, because as you know, that's his purview. That's not mine in terms of what that's based upon what's going on at any given point in time in the building for our continued safety. But I disagree with you about
Well,
that.
I understand that, but some of us do show up early.
Okay.
And when we do show up early, the jurors are sometimes checking in at
When's the
same-
last time this happened, madam?
When's the last time, excuse me?
When's the last time that you were checking in potential jurors are being brought up?
I can say the last time the jurors were here, I know I was here early.
What date?
Let me look at the schedule. So I could say August 17th. We were supposed to be here for 1000 hours.
Mm-hmm.
I was here at 0900, between 0900 and 0915. And I believe jury services is telling them to be here at 0900.
Okay, but did you go in the courtroom?
I sit outside the courtroom, and sometimes the
Have you already
deputies,
been screened?
so sometimes the jurors,
Answer my question. Had you already been screened?
well, I have to ask them, are you searching bags now? Or they'll say, we're not searching bags right now. And jurors are walking the hallway, or they're next to the desk and they hear this interaction.
What interaction?
But are we being searched now, or are we going to be searched? Between me and the deputies who are in black tactical gear.
Okay, all right.
So if you do show up early, that's the situation you're gonna come upon, is jurors hearing that we're gonna be searched, or they see us being searched.
All right.
And
I'll look at, to Mr. Steele's point, I'll talk with our sheriff and see what can be done in regards to, so that the two can be separated or separate. But I'm gonna tell you, like I told you a couple weeks ago, you all have to get here on time.
right, well, if you do show up early, you might be in the interaction in front of the jurors. And then I did ask if you
And
could be,
use your wise discretion. I mean, you're counsel and you know that you're not supposed to have anything to do with those jurors, right?
well, of course, but
As
I
an
don't want
officer of
them,
the court.
right, but I don't want them to hear that I'm being searched, or that the deputies later are going to be searching me.
And that's what I'm saying.
Because it seems like there's a level of distrust between the attorneys and what we're telling them, because they're potential jurors.
Well, I will let the sheriff revisit his particular piece of the puzzle, but I'm gonna tell all of you to make sure you're here on time, okay?
And then I did ask if they could search in the vestibule, because at least that's away from the jurors. And they said that that was a security issue.
Like I said, I'll talk with the sheriff about that and see what, that's your concern?
Right,
I understand exactly what you're saying. So-
Right, just for the search to be done out of earshot, or for the jurors to see it.
And then the other thing, Mr. Williams, as you well know and your other colleagues know, is once we get a jury, they have a separate entrance.
Right,
It will not be an issue. I don't believe it will be an issue
right.
because,
I believe it-
they won't see you and you won't see them.
Right, I'm just concerned because these are potential jurors that might be
Understand.
seated. And I don't want them to have a bad taste in their mouth before we even open our mouths.
All right, well, come on time and they won't have a bad taste in their mouth because I can't blame all of you, which I should be able to, but I can't. So if I can start on time, then I don't think that we'll have some of these problems. I'm telling you.
Right, well, like I said, the people who do show up early, we're having these
And
issues.
I can get the sheriff to potentially address that. So I'll have a meeting with him about that.
Thank you, Your Honor.
What else are your concerns?
That's my only concern. Thank you.
All right, you're very welcome, ma'am. Mr. Weinstein?
Your Honor, I have nothing to add with what Mr. Williams said, other than to just repeat her statements and affirm that when we are here early, these events do occur where the jurors are seeing us searched or seeing the interactions between us and
Okay. It just stopped now. But listen, I wanted to show you guys this other guy, the one I was just telling y'all about, that he was, hold on a second. Hold on, I'm gonna show you guys what he looks like. They don't have shackles on his ankle or anything like that. Hold on. Let me get him so you guys can see him. Hold on a second. Hold on, I'm trying to get a picture of him. Okay, I'm gonna show you the guy. Let me show you him. They're going for the death penalty on this guy. He pleaded guilty. He's the one who killed 8 people. Okay, hold on a second. Let me show you. I'm just showing you the difference how they treat certain people and how they treat another group of people. Look at this guy right here. Look at him. He's sitting over there with his attorneys. You see how the officers are standing like way far away from him? You see where he's at, right? And in that courtroom, you can go in there. I was in that courtroom. Hold on a second. See. Let me show you some more stuff, some more clips from it. Hold on. Okay. Now this is the 2 parties. This is the victim's family. This is the victim because they deceased, but this is the family of the victim. They're inside the courtroom, and you see, Mr. Williams' family cannot be in there, but this individual, his family, and the victim's family are in the courtroom. See, that's the family of the victim. And then on the other side, you'll see the family of the guy that they're trying to get the death penalty on. And Mr. Williams' family cannot be in the courtroom like these people are. Hold on. Let me see. No, I mean, hold on. Let me show you the people. It's like double standard, y'all. Hold on.
Subject to the court's calendar. The one thing I would...
Hold on a second. Just 1 second.
Your Honor, just to ensure that we...
Okay, hold on. I'm going to show you this guy. And just a second, y'all. I just want to show you. Okay, here we go. Look at this. This is the guy who murdered those 8 people. This is him. See, look how he's looking dressed up and not all the security around him.
Dates available, Mr. Lamar, I'd like to check with expert regarding the grand jury challenge. He has already hearings set for the rest of September. Or the week of the 18th is available.
Yeah, it's the same massage parlor guy. He killed 8 people.
We can check for that. He's on call. He's on alert for us to get clarify dates with him. So we just have him on that.
Yes, ma'am. Oh, absolutely. I can recess in place.
You see that right there? Hold on a second. And I'm going to show you his family, which is straight in the courtroom. And remember, this guy here is supposedly dangerous, right? Very dangerous. Because he killed 8 people and he admitted to killing them. but they treat him with much more leniency and respect. Hold on. Here we go. Here we go. Now watch, you're going to see his family in the background. Totally different. You see that, right? Hold on, let me show you the family. Hold on. I'm trying to show you the video with the family.
One moment, Your Honor.
Yes, ma'am.
Hold on a second. Hold on a second. Let's see. I think I may have the family right here. Okay, now here's his family right here. His family's in the courtroom with him. I'm going to show you guys right here. Let me just show you the difference in between the, hold on a second. Now, this is the family of the guy inside the courtroom with him. You see the family? Look at him. See, the whole family's in there. Hold on. See, look at that. You see that, right? Family's right up in there with them. And he's treated differently. He doesn't have all those shackles on his the ankle and all that kind of stuff. He doesn't have, and look at this guy. Look at him. I'm gonna show you. Look at this. Look at this. No shackles on his ankle, no brace on his ankle, none of that stuff. None of that stuff, y'all. And this guy, he already pleaded guilty on the other case, and he got a life without parole. And then the case that he has in Fulton County, they're going for the death penalty. Now this guy, he's a convicted murderer. Yep, he's a convicted murderer because he pleaded guilty, and they're just trying to see if he's gonna. Yeah, he's sitting there very comfortable. You see that, right? Look, I mean, just look at this. Let me show you. Totally different. Look at this. Look how he's sitting there. Look at that. Look how he's sitting there. See how far he's sitting very comfortable. No shackles or anything like that on him. Because when he came into the court, he was walking regular, none of that metal thing. None of that was on him. And his family's right there with him. Not so with the Williams, Mr. Williams, or any other people on the other side. And let me go close this out. Okay, let me go ahead and finish playing this other video. Hold on. All right, here we go. Oh, it's not playing. I hate when this thing do that. Oh, I hate when it does that. Why does it do that with this one? Hold on, y'all. I apologize.
Thank you, Your Honor.
What else are your concerns?
Add with what Ms. DeWilliams said, other than to just repeat her statements and affirm that when we are here early, these events do occur where the jurors are seeing us searched or seeing the interactions between us and the deputies on the searches. Also, by the way, we'll also say
Hi,
the
Ray.
deputies, again, are nothing but courteous when this is happening.
Okay, I can potentially, we'll figure a workaround for that.
Thank you, Your
All
Honor.
right. Anything else before I let the state respond?
No.
Okay,
Thank you, sir.
all right, no problem. Counsels? Mr. Uhelski?
Your Honor, the state, as much as any of these defendants, wants a fair trial to occur here. We do believe that the security measures that are in place currently are appropriate, and the Sheriff's Department's doing a great job, and Your Honor has supervisory authority over it and discretion, and that means there's no hard and fast rule on what to do. So what's been working is what we would ask the court to continue doing. I did hear, I guess I'll start with the proffer. I heard Ms. Williams speak that she's in earshot of jurors when she's asking, am I going to be searched now or later? I would basically just point out that she could refrain from asking that question in front of jurors, and that would eliminate or alleviate that potential concern. But to the motion itself from Mr. Williams, I do want to point out that his citation to Holbrook v. Flynn, where it says that if security are around a defendant, it creates the impression that someone's dangerous or untrustworthy. In that case, they expressly found that there was no such impression created by that police presence. Similarly, in Chancey v. State, where it's alleged, I think Mr. Steele has just said that there's a fortress-like atmosphere based on the presence of these armed security personnel. In Chancey v. State, that decision expressly held that that wasn't a fortress-like atmosphere, and the court wasn't wrong to have security in the way that they did. What I do want to point out, and without belaboring, too much, what I think the court may already be of the opinion about, is that the excessive amount of sort of disciplinary incidents and infractions that we've experienced since the beginning of trial in January, I think sort of underscores, if we need to be reminded, the need for increased security measures. And I'm not sure if, for instance, Williams or Mr. Steele is objecting to, for example, how the courtroom is right now, how it's been in the past. It's a little bit nebulous, but I do want to point out that there have been multiple incidents and infractions that highlight the need for increased security, which this court and the Sheriff's Department, I think, is authorized to meet. Starting with in January 17, we have Diamante Kendrick's mother and girlfriend attempting to deliver tobacco within legal documents. That goes to the idea of why these searches may be appropriate. January 18, next day, Blaylock and Ryan have shanks in their jail cells. These are in and out of court disruptions, but they, of course, highlight the need for the security and the safety of all persons involved in this trial inside the courtroom and out. Same day, January 18, 2023, you have the in-court alleged, drug handoff, as Your Honor may remember. The incidents go on. January 23, 2023, Rodale Ryan spits on Fulton County Sheriff's investigator while awaiting transport to the courthouse. January 31st, 2023, Eppinger, Ryan, Blaylock, and McMullen stabbed an inmate collapsing his lung in the jail.
They're alleged incidents one time, but they go to the posture. So I'm gonna allow it. I'll allow it, Mr.
Address
Matthews.
that comment, which is to say that these incidents, which I'm still going to go through, resulted in the issuance of no fewer than 46 arrest warrants, meaning that there's at least probable cause, there's a fair probability to believe that these things occurred. They're not just alleged, okay? March 23, going forward, Durante Beebe threatens a Cobb County deputy by saying, "I got something for you. I'm surprised you ain't died yet." This is at the Cobb County Adult Detention Center, I believe. March 29, 2023, Stillwell threatens a female during a call he made from a cell phone in jail. He's got a cell phone in there, AirPods, a shank, cigarettes, and some 173 ecstasy pills. I mean, these are security breaches, all. April 5, 2023, Kendrick has an iPhone and an Apple AirPods in the Fulton County jail. They're not supposed to have that stuff, Judge. April 15, 2023, Sincarius Mender has Apple AirPods, some 73 Percocets, cash in 20s, 2 phone chargers, cigarette lighters. This is in Fulton County jail. April 17, going forward, Mender, during transport from courthouse back to the jail, is found with marijuana, Percocet, hydrocodone, etc.
The motion had to do with the issue of these.
Mr. Matthews.
Being searched in the presence of.
Mr. Matthews, all of this pertains to the security posture in his background. So I'm going to, again, for the second time, overrule your objection. It's just a proffer that's being made for the reasons of the security posture that this court has had to look at. So he's just laying a predicate.
To finish the April 17, 2023 incident, for the record, Mender being found with these items of contraband to include marijuana, Percocet, hydrocodone, morphine, tobacco. These were in an envelope contained within his legal documents. This is, again, highlighting the need for whatever measures the Sheriff's Department deems fit to make sure this stuff doesn't make it into this courtroom. Your Honor shouldn't have to tolerate this. Going forward, April 19, 2023, Ryan is found to have 2 large rolls of marijuana sewn into his underwear while court is in session. April 29, 2023, Dorsey allegedly shanks 2 inmates at the jail. May 1st.
We're gonna object to that. Actually, we just had a print on this yesterday where the officer testified that the video, so there's allegations and there's also probable cause. And the officer testified that after reviewing the video, she got warrants before the video, then she reviewed the video, and in the video at no point does Mr. Dorsey attack anybody. What they believe is that he orchestrated things, but there is nobody that can put as they put it, shank in his hand. He didn't even throw a punch. He did absolutely nothing to these 2 individuals that apparently were having their Cheetos or something stolen by 2 other individuals. Mr. Dorsey is not seen shanking anybody, so we absolutely object to that being put on the record. And that is not the courtroom. That happened at the jail, and many of these incidents that they're bringing up as purchases and pills and cash and cell phones were most likely brought in by members of the Sheriff's Department, not by their attorneys and not by the clients themselves.
I'm gonna overrule your objection. I mean, just for I'm not here to resolve any other issues that are not before me in terms of allegations of purported criminality. This just goes to the court security issues as postured. So that's the only reason I'm going to consider it, for that reason, Mr. Jimenez, and that reason only.
Sure, thank you, Judge. And with that in mind, I'll say on May 1st, 2023, next, the state has reason to believe that there was
When was what, Kev? Kevin?
Jail cells enabling an aggravated assault.
Ray. Oh, Ray, I wanted to tell you. Hold on a
May
second.
14,
Hold on.
2023, the state has reason to believe.
Hold on a second.
Nichols and
Right. I wanted to tell you, the ones that are doing this are those that are already serving time. They have time conviction. They have gone to trial and they are convicted, and they are there to do this trial, but they're already in jail. I mean, in prison. They're not getting out. A lot of them already have lifetime service. When was this court going on? It was going on today, earlier today. This was this morning. But right, that's why they doing these things with the shanks and all that kind of stuff, because they don't have nothing else to lose. No, you talking about Kendrick and you talking about that Kendrick didn't have shank. Kendrick, they claimed that Kendrick, remember I told you the situation with that the mother did not bring that in there, because I was right there when the young lady had asked the mother to take it downstairs for her. No, this is Dorsey with the shank. It's Eppinger, Ryan. Those are the people that have serving life sentences. That's the ones that's doing all this craziness.
were involved in a riot at the jail where Mender is seen leading the melee. May 15, 2023, state has reason to believe DB was wearing unauthorized clothing articles at the Fulton County Jail. May 16, 2023.
Yes, definitely, right.
And Eppinger refused to comply with commands.
See, that's Eppinger they're talking about.
Physically resisting the efforts to achieve compliance. And Dorsey began hissing.
That's Dorsey right there. He's serving life.
Eppinger stated.
Eppinger serving life.
Right now. It's on. May 16, 2023. Eppinger is fighting with
Eppinger again.
He's attempting to remove his leg brace while being transported from the courthouse to his jail cell.
To my Eppinger.
May 17, 2023. Dorsey is
again.
Reason to believe, in possession of unauthorized clothing articles within his jail cell.
And I object to that one. I want to give some context because it's very basic. What I say is, quote unquote, my client was wearing Air Force Ones, which are some white tennis shoes that are very popular. He had them on that day. He was taken from the courthouse to the jail. They did not provide him with the jail Crocs or whatever sandals. He walked with those shoes on to the jail. There was nothing
murder.
Concealed.
Eppinger shot at a police officer. I don't think he killed him, but he shot at a police officer.
He has no ability.
But Dorsey is murdered.
They
2 murders.
And then they charged him because he walked to the jail with the shoes he was wearing in court. I know that's very dangerous because they are Air Force Ones, but he had no other option. And when that case is finally indicted, we will probably have a trial.
Okay. All right. Thank you, sir. All right. Mr. Uhelsky, go ahead.
Yes, Your Honor. Wrapping it up here, May 25th, 2023, state has reason to believe that former Fulton County Deputy Sheriff cultivated some sort of relationship with Eppinger, whereby she's communicating with him on Instagram through an illegal contraband cell phone that she knew he had. She attempted to bring him contraband from one of his family members. And finally, June 16, most recently, 2023, we have reason to believe that Dorsey refuses to come out of his jail cell for trial, delaying the start of proceedings. The reason we bring these up is not to say we know to any degree of certainty, any one of these things, but the incidents as a whole are highly disruptive to these proceedings, whether they're in the jail, on the way to the jail, in open court. The idea here is that, you know, the complaint of extraordinary police presence is, at least to some substantial degree, self-inflicted by these behaviors. You know, the security concerns that demand the increased police presence that the state believes is appropriate at this time have been created by the behaviors of the defendants themselves. And it's, you know, within obviously this court's purview to approve of such increased security procedures. I'll point the court to the United States Supreme Court in Holbrook v. Flynn to do with sort of the optics of, you know, restraints, increased security personnel. Supreme Court said in 1986, while shackling and prison clothes are unmistakable indications of the need to separate a defendant from the community at large, the presence of guards at a defendant's trial need not be interpreted as a sign that he is particularly dangerous or culpable. Jurors may just as easily believe that the officers are there to guard against disruptions emanating from outside the courtroom or to ensure that tense courtroom exchanges do not erupt into violence. Indeed, it's entirely possible that jurors will not infer anything from the presence of these guards. If they're placed at some distance from the accused, security officers may well be perceived as more of elements of an impressive drama than as reminders of a defendant's special status. It's true that the defendant has a right to be tried in an atmosphere free of partiality created by the use of excessive guards, but there's an exception, and that's Allen v. State, Your Honor, 235 Georgia 709 at 711. There's an exception where special circumstances exist, which in the discretion of
If you
the trial
notice,
judge,
none of it said Shannon did
dictate
anything.
that.
None of
What's
it
the section,
has
Alan,
that's going to be
Thugs doing
235
anything. Those
Georgia
two is not doing
709,
anything. You didn't hear anything
pin
about
site
Kendrick.
711.
He's not doing anything. The only thing that had Kendrick having is a phone in
addition to
his
that case,
thing.
we cite to the court State v. Cruz,
Other than that, all this extra stuff
which
is
says
not
that the
them.
trial court again has discretion, and discretion again means there's no hard and fast rule there. It's open to what the case by case demands arise are. But
You said the
trial court
guards
has
are worse than
discretion
the
to determine what
inmates? Oh,
security
wow.
precautions are reasonably necessary to ensure that the courtroom is secure and conducive to the conduct of a fair and safe trial.
Phyllis,
that is
somebody just died
343
today.
Georgia Appellate 289, and the pin site is
And
293.
one person just died
294.
today. He got shanked to
That
death.
is, all these cases, Your Honor, are in the
Got
state's
stabbed.
response, that I believe was filed August 20th or thereabouts. And of course, the trial court is charged with reviewing and supervising, as I've said, but the measures that are actually implemented are, put in by the sheriff's office, which I believe nobody says they distrust here. And they've been treated courteously by, as to all defendants. Not only Georgia courts, but federal and state appellate courts regularly uphold the use of enhanced security measures on an as-needed
Kevin,
basis.
I was looking
So,
at the article.
we already talked
Hold on
about
a second.
Holbrook. In that case, there was no prejudice to a defendant based on the fact that there were 4 uniformed and armed officers sitting in the front row, in addition to 8 other officers.
Hold on, y'all.
In Muhammad v. State, this is a Georgia Supreme Court case, 307 Georgia 89 at 94. That's a 2019 case. This was in an ineffective assistance of counsel context, but the Georgia Supreme Court held that it was not error to have enhanced security measures, including between 5 to 10 uniformed officers spread throughout the courtroom. And there the court noted as follows: we doubt that many jurors would think it remarkable at all to see enhanced security measures in a case involving 3 inmates accused of murder. The jurors knew that the defendants were inmates, and their awareness of that fact lessens the danger of prejudice from enhanced security. Going forward, Spivey v. State, Your Honor, 253 Georgia 187 at 203. Our Supreme Court held there that the presence of uniformed guards around the defendant in the courtroom didn't violate his right to a fair trial. In particular, they said because the officers didn't surround him and the number and the location of the officers varied, as we have here, there was a failure to show that the number was excessive or that their presence was ominous and beyond what was inherent in the presence of just guards in general in a courtroom. There's more authority for this. Zant v. Gaddis, we could go on. But Your Honor, these security measures are appropriate. And I do want to deal with one or two other issues outside of the security measures to do with guards. I want to talk about the sort of restraints. For one thing, they're not visible. Okay, you can't see them. So for them to be claiming prejudice to something that's invisible to potential jurors, or even, if a jury is seated, that's not going to be something that is going to be error when security demands that these measures be put in place. When it comes to searching bags upon entry to the courtroom, the United States Supreme Court says that it's okay when it's necessary and reasonably tailored to prevent further contraband from making its way into the courtroom. We have had that here. The state has reason to believe, and we believe that the searches at their present status are appropriate. And that citation to the U.S. Supreme Court is Chandler v. Miller. It's a 97 case. It's 520 United States 305 at 323. In that case, the Supreme Court specifically held that administrative searches such as the kind we have here, which are calibrated to the risk present, are going to be reasonable, and they're not error. I don't think I have anything else to add, Your Honor. If you have any questions, let me know. But I'm gonna leave off at that point if Your Honor's
Okay.
satisfied
All
with
right.
the presentation.
Thank you.
Oh, can I add one other thing?
You said sit down out there. You're good. You're good. You're good. You're good.
I'll take it.
Okay. All right. Thank you, sir. All right. Let me just address a couple of just global things that were raised by Mr. Williams' motion. Okay. And in taking a look at the latest pronouncement under CASAS, CASAS versus the state at Court of Appeals decision from June 27 of 2023 at 890 Southeast 2nd, 305. That case more so deals with the issue of restraints. And of course, restraints are dependent upon the circumstance. And, and it is the court's duty to provide, a environment that fosters as cited by all of you, defendant is entitled to a trial free of partiality, which the presence of excessive security measures may create. It's also well established that the use of extraordinary measures to prevent the dangerousness or disruptive behavior which threatens the conduct of a fair and safe trial is within the discretion of the court. So I will take into account, Mr. Steele, what you said in terms of restraints. I'll leave that within the discretion of the sheriff's office, depending upon the circumstances that present us as we go forward. And I'll ask the sheriff to review those as appropriate. But given the allegations of what has occurred before coming to court and in court, as a totality, I mean, the issues that we have are in terms of security and secondary searches, administrative searches, have been reasonable under the circumstances. I would also ask each individual counsel to review there's individual circumstances with their clients, because that may make a decision as to the sheriff and what he is willing to do at that point in time. And so I would just ask you as professional advocates to do so. I will, on the other hand, ask the sheriff to take a look, or he and his team to take a look at the secondary screening measures and where those occur. But I also would remind everyone, that as officers of this court, it is your duty not to have any contact with jurors. And it would be within your wise discretion to just say, hey, I'll get screened another time if you believe that a juror is present and is going to be there. Plus also, once this trial commences, these jurors will be taken in a separate entrance and you'll not see them until they're already seated in the courtroom. So that may resolve part of that, but I will go ahead and have that conversation about it with the sheriff. As it pertains to 8H in the gallery, I'll ask our team, our audio team, just to make sure that those speakers are functioning correctly. As you well know, this is the largest, we're in courtroom 1C. It is the largest place that we can have court of this nature. We've configured this courtroom several times to deal with your concerns in terms of being able to see. If you are not able to see, please raise that to the court's attention. This is the first I'm hearing that if you're in a particular location, you can't be seen. So we can kind of take that up with Captain Kendall and her team. But and I'll have her come down, and Mr. Steele, you can kind of tell me, okay, where it is. But in terms of the vantage points and the rotation of individuals throughout that is also part of the security pattern and practice. So I don't know when that's going to happen. The sheriff and his team certainly that's within their discretion. But I will make sure that no matter what position you're in, that you're able to kind of see things and you are not otherwise obstructed. Some of you have I think have a better vantage point than others, but that's why we have these additional monitors and we have some additional things. So to improve your ability to see and hear the proceedings. But at any point in time, you are unsatisfied or you're not, or it's not working for you, please let us know and we'll address that. The court will address that as much as I can. And I've continued to do that at many of you's bequest. Hold on 1 second. So I can pledge to all of you that the security posture will be evaluated on a continual basis. It will and it will much depend on the individual circumstances as to what is going on. But given all of the things that we have experienced thus far, that is why the position that we have right now. But this court is committed to giving each person in here a fair trial and will free of partiality. But the security measures definitely are driven and will be evaluated based upon what's going on at any given time. So either inside and outside, because they do affect all of you in here. And my overall goal, as Mr. Steele started out with, is to keep everyone in here safe and to provide a safe opportunity for you to try the case that you need to try. So, yes, Ms. Love.
Thank you, Judge. Your Honor, along the lines of ensuring that people who are in H can see what is going on during the proceedings, we have not brought to the court's attention, but I felt like this is a good time to do so. Our victim advocates have brought to our attention that 8H is sort of a communal viewing room for everyone, and victims are the people who have statutory rights to be inside the courtroom or to have the ability to see what's going on. So if I can just put in the court's, in the back of the court's mind right now, we're requesting a place for victims to be able to view the proceedings. We do not want to create an unsafe circumstance in H where we have people who are family members of the accused and victims' family members. So just if there's at some point we can come back around to having a space or victims and family members of deceased victims can view the proceedings, I would appreciate that.
Well, I'm open to suggestions. If you have a location that is otherwise not unencumbered, or you have another solution, I can go ahead and consider it. So I'm more than willing to open to suggestions.
Right. I will bring that to the court's attention because I believe we do have a few. So
Okay.
thank you, Judge.
All right. Okay. All right. So consistent with the court's directives, I'll go ahead and have some conversations with our sheriff, and I've noted your concerns for purposes of the record. Okay. All right. The next issue is a motion for a discovery index filed on 6/28 of 2023.
Your Honor, thank you again. So we have had 12 productions in discovery, ranging from, I believe, July or August of last year through a couple of weeks ago. And I have done my level best to go through every bit of that discovery, as I'm confident everybody here has done as well. What I'd like the court to do is order the prosecution to provide an index to the discovery. What they did was, and what was originally said to this honorable court by District Attorney Geary, then District Attorney Geary on the case, was everything would be in a folder and it would relate to the overt act and be identified that way. A lot of the items are in that fashion. But inside of that folder, let's say, for instance, folders number 16 through 20, I'm just giving an example. There's and it reads ICM CDR report 1, and it's 431 jail calls. And then there's an ICM CDR report 2, 30 jail calls. And I'm going through these jail calls. But these jail calls have nothing to do with folders 16 through 20. There's a miscellaneous file in the Donovan Thomas folders, Your Honor, that has a tremendous amount of information. It has nothing to do with the Donovan Thomas. He's a gentleman who, God forbid, was shot and a fatal gunshot on January 10th of 2015. All I want is, and I know the state must have it because I can't believe that, I just can't imagine they don't have it, but just a list of, in this miscellaneous file is the following. In this file is the following. I don't need anybody to do any work for me. I'm not asking, I'm asking for the index, which I think is appropriate when you're dealing with this much discovery. Instead of labeling something, police reports, you could say police reports of, or police reports dated, to make sure that we're all on the same page. That's my motion and request.
Okay.
Thank you.
All right. Counsel for the state.
Your Honor, I'd just like to briefly respond to also about with some law of the court, but what we have attempted to do, Your Honor, we have attempted to go above and beyond what our statutory obligations are, and we've tried to be as professionally courteous as we could and provide to counsels for the defendant in as organized a manner as we could all of the discovery. It's a voluminous case. It has terabytes of data, and we do not have an index, as Mr. Still put it. Each of us has on terabyte drives and storage drives, hard drives, data that are in folders. We have provided that to them in, as I stated earlier, the most organized fashion that we could. Beyond that, I'd ask the court's permission to just allow Mr. Helsey to supplement what I stated with the law that he has.
All right.
This is just briefly, Judge. I believe the state has a duty under the circumstances of discovery to make correct and complete disclosures. But I think that the duty reasonably investigate and aggregate those, so that doesn't fall to the state, that falls on the defendants. And I just want to point out that there, complaints that there's too much discovery to go through and that we should have. I think that you don't have, I don't think it can be navigate the discovery for that, that's your job.
Without anything else, Mr. Steele, I mean, I think you've done a yeoman's job of identifying things that you want the state to kind of flesh out or determine if there's anything else, or to that extent, you can certainly continue to raise those, but I don't believe there's any duty for the court to provide them to require an index.
I believe under professionalism, there is something the court should do. I don't understand what the honorable prosecutor just said about investigate and navigate too much discovery. I never said anything.
I know you didn't.
That's just far-fetched. And to say that the state doesn't have it, they can't do it, they just have folders. They dumped on me, Your Honor. They dumped on me. Tremendous. This is a huge effort. At least all I'm asking is for a list of what is in the folder. They don't have to go into,
Have you sat down with the state to ask them?
Yes.
I mean, I know you all have had various conversations with your colleagues from the state of Georgia about different issues, but is there something that could be done through a conversation more than anything else?
I've asked the gentleman right there, who's been nothing but, I've told the court this over and over again, he's been nothing but receptive. His name is Prosecutor Smith, and he said he would talk with Miss Love. I've never gotten I've never gotten an index. All I want is an index. We are talking, and the court knows what terabytes with an S. I don't know if it's 5, I don't want to represent, but Mr. Smith would know how much was sent. It's just, we're going to get into trial, and I'm just telling you what's going to happen. And nobody should want this. I'm going to say, I can't find that. You're going to say to me, why are you delaying this? And I'm going to say to you, Your Honor, I can't find this. I don't believe I was served on it. Then you're going to look to the state. Where is it? Mr. Smith is going to know exactly where it is because he knows where everything is. He's going to tell me, and then all this is going to take 30 minutes. All I want is an index. If it can't be done because the state has no idea what they sent us in these folders, well, then that's a shame.
Okay.
I'd like to respond just briefly, Your Honor.
Yes, ma'am.
Your Honor, we have, I believe that we search certificates of discovery, which would have some breakdown of what's in the folders. Again, to ask that the state does the job that the defendants also have an obligation to do, which is writing down what you have, seems a little in excess and far beyond professional courtesy or professionalism. Your Honor, so I believe that I can accurately state that we've, to the extent that our legal assistants and our deputy legal assistant has recently, while we served discovery since we've been on the case, provided that to the defendants. They have been breaking down what's in the folders or what's in the files. We just asked that the court require defendants to do their diligence as well regarding going through the discovery. Because as we give them as we turn over files and folders to the defendant, I personally sat with Mr. Sharp and I believe Mr. Weinstein 2 weeks ago and went over some files and showed them where it was and showed them how to get it and ensured that our certificate of discovery, which indicated the files were there, reflected that they were able to access them. So we have been doing our diligence. And Your Honor, I'll just point the court's attention to one of the certificates of service that was filed December 7th, 2022. And just to give Your Honor an indication of what we're looking at, I can bring to the court the breakdown of this particular certificate of service, Dropbox link 6.
Is it an Odyssey? I'm sure it is,
It
right?
is.
Okay, I'll take a look at it.
Thank you, Judge.
Okay.
So to that extent, that we have been providing discovery to the defendants since we've been working on the case, they have what Mr. Steele was asking for, but further than that, we'd ask that the court require defendants' counsels to do their diligence as well as the state.
Okay. In terms of your request for a discovery index, Mr. Steele, I'm not gonna, to the extent that when it's discovery, the certificate has been filed, in this case, in Odyssey, and represents what it's supposed to represent. If it's inconsistent or you need to, ask the court's assistance for that because you have something specific, I'll go ahead and hear that on as needed basis. But, and we'll just take it up from there, but I'm not gonna require them to do a global index. It's gonna also, but I will just say that, again, in the interest of you all as professional advocates, have the ability to, communicate one to another. I mean, it's a lot of information. Everybody's got a duty to go through it. And if you have any concerns or any issues after that you need to particularize or otherwise bring to the court's attention, I'll be more than willing to, like I said, listen to it on an as needed basis. Okay.
I just wanted to add something to regards to that, and I think I might be able to phrase it a little, because I've gone through it. The difference is there is, might be just my misinterpretation, but there is a sense that is a dump of just like in a civil case, where you have a big, you have a big class action lawsuit, and then they try to bury the actual relevant stuff.
The truck comes up and you got 1,000 boxes of stuff.
And,
Okay.
Trapman and whatever might have a great, a team to go through that, but now I got twice as much bandwidth, but it's two attorneys, at least in this table. The last discovery that was given to us was half a terabyte. That is probably the equivalent to, watching Netflix for a whole week nonstop. It is not something that is doable, and I join Mr. Steele, I do not believe that the state is also flying blind with what they have. They have their case, they know what they're going to present, they know what they're going to use. We're not asking for the strategy, we're just asking for guidance as it was promised. The folders are labeled, incident or predicate 1, 2, one of the many dozens of predicates. But the information within it is not always what it purports to have been. It is just a bunch of calls or a lot of videos or a lot of reports that are just not really linked to that. So if I am to focus only on Mr. Dorsey, and I only focus on them, some information that is related to Mr. Dorsey is sprinkled and scattered through other acts that would have nothing to do with him otherwise. Like some young man standing with a tattoo picture on Instagram that's got absolutely nothing to do with Mr. Dorsey. But I'm not sure if in his folders there is not information relating to my client. Again, they have to have some sort of list. I don't need your notes, I don't need your work product, but an accurate delineation of what it is. And I found some troubling stuff on the last dump, and I am working on a motion. I'll hopefully particularize it and get it to you by the end of the week. But we're just asking for more specificity as to what they intend to use to prove the counts as it was promised, not just a dump of information, because a half a terabyte just in the last dump we don't have enough time. That should have been given to us by the statute 10 days before trial, and trial started January 4th. So if they're gonna go with what they have, duties that they have, and that they're going by them, then let's do that. Let's only admit discovery that was given to us by December 26, 2022.
All right, well, I'll take it up, like I said, I'll take it up on an as-needed basis, and, because you all have a continual obligation if you've opted in, so.
Your Honor, can I just add one thing, please? I appreciate that the state has given us multiple sets of discovery. There appear to be organized in a file structure, but I just want to repeat that file structure is not necessarily accurate with what's in those folders. And let me just give an example so that you can understand this. I went through initially and did what most people did, or a lot of people I assume did, and I pulled out all of the folders related to Mr. Kendrick. But then I went back through, and fortunately, I'm old as dirt and an old software guy from the 70s. And I used a tool called grep, an old Unix command, to go back and find every incident where his name was mentioned. It shows up in all kinds of areas directly related to the counts against him, but not in those folders. So while there may be a structure there, I don't think the state, and I'm not accusing the state of trying to hide anything, because as Ms. Love has said, if we have questions, they are happy to help us find things. But the structure that we have and the information that we have is somewhat haphazard. Not that they intentionally provide it to us in that fashion, but that's just the way it is. So without an index, without something else, we are left to chance or fortunate computer skills enabling us to find documents relating to our client. And I do not have, this isn't a pharmaceutical patent case where I have 20 associates that can get there and go through discovery. Yet the amount of discovery is comparable to that. And without structure, it is very difficult to find the documents related to our client and to properly defend him. Thank you.
All right. All right, here's what I'll say, and I'll say this to all parties, okay? Stay to the extent that Mr. Weinstein has kind of framed the issue. I know that you all have provided discovery certificates and the like in terms of the folders and what purports to be in the folders. But if there's any other way of navigating or searching these particular files that you all can share with your colleagues that would make it more meaningful, that I would encourage you to do that for more than many reasons, because and I just kind of leave it at that. I mean, there should be no surprises when we go to trial. But I share the concern that there may be, if I can't find everything or there's not a way for me to search it, because you all, I agree with some of the things that have been said. You all have a way to manipulate this discovery. You're not just kind of, you've gone through it. So there's got to be a way that you're managing this information. You don't have to necessarily share that in trial strategy, whatever else, but searching it, I mean, I think that if you don't want there to be problems later, I think that you probably should at least kind of sit down with the defendants as a group of attorneys and just kind of just indicate, okay, here's how we search for X or Y or whatever else, or here's where it is, and let them decide what they want to do from there. But
Judge, thank you, Your Honor, and I can appreciate the framing as well, but I do want to just state for the record that a dump, this has not been, we have not in any way, neither have we endeavored to simply do a discovery dump, nor have we in fact done any discovery dumps. Each provision of discovery to the defendants have been delineated. They were delineated in a certain manner prior to November of 2022, and they have been delineated in various other manners in an effort to make very clear what the information contained inside each folder is. And to the extent that there is, again, the suggestion that we are hiding the ball or keeping something that would make it easier to navigate from the defendants, Your Honor, I categorically state that that is not the case. We are familiar with the case and the cases and the information that we are providing to the defendants because we are requesting that information from law enforcement. And as we get them, personally, when I provide things to the defendants that I've obtained from law enforcement, I label it, incident on Adele Avenue, incident on Rice Street, incident on whatever. And so that it may be that Mr. Weinstein's client, Mr. Steele's client, Mr. Harvey's client are all involved in that incident. It's not going to say the names of the defendants, but it's going to have the incident name attached to it. So the ways that we navigate this discovery that we have provided to them are no different than the ways that I'm certain they have been able to, and I'm certain they have the ability to navigate it as well. The difference between our abilities and theirs as it stands right now is that we know what we had to request and we are labeling the information that we give them in a manner consistent with what that information is. It is not by defendant, it's about incident, Your Honor.
All right.
Your Honor, may I just clarify what I was saying very briefly?
Mr. Weinstein, would you be willing to share that tool that you have with the rest of your colleagues?
It is an extraordinarily difficult tool to use that if you're not a CS major, I don't know if you could really use it. It's grep, G-R-E-P, grep. It's a Unix line command. It's very clunky and ancient. I don't think it's really suitable for most folks to use.
Is there another?
I wouldn't use it in polite company, Your Honor.
Is there another tool that can be used?
I don't know about that, Your Honor. No, not Control F. Also, I want to say again, I do not believe that the state is intentionally hiding anything, but the incidents are not necessarily filed in the folder in which they should be found. I'm not just talking about names randomly showing up in the wrong places. I'm talking about things that, and I understand it's a large sprawling case, everything is not going to be perfectly filed, but items are a bit scattered, likely through no fault at all of the state. It's probably the way it was given to them. I don't know, but it just does make it extraordinarily difficult to find everything. We do not have a tool that's been provided to us that we can use to go through and find the documents that are related to our client. We have a very basic file structure and nothing more. So that's an issue.
Okay, you all know, probably know that the civil cases are a little different than criminal cases in terms of discovery. But the Criminal Practice Discovery Act, 17-16-1, etc., is to establish a closely symmetrical scheme of discovery in criminal cases that maximize the presentation of reliable evidence, minimizes the risk that a judgment will be predicated on incomplete or misleading evidence, and fosters fairness and efficiency in criminal proceedings. So again, I would just kind of just, remind everyone to include the state. I think that disclosure is better than non-disclosure in terms of what potentially may be used later. And, you know, you don't run into any Brady or other issues by just kind of, hey, here's where it is, you know, and you're indicted, you should be able to prove it. So I'll leave that to you all to kind of just continually just kind of update. And if there's any issues, any counsels as to your being able to not, as Mr. Steele filed several motions about incomplete or other things that he wished to have, I'll be here to rule on those. Okay? All right. Okay, motion for discovery 21, Mr. Steele, filed on 6/28/23.
Your Honor, provided in discovery was on or about March 3rd, 2022. There was a debriefing held in your courthouse on the district attorney's side of the courthouse. And it was to educate people on the prosecution team about the wiretap that was signed in this case. And during the debriefing that was provided, Investigator Viverito, which is Viverito, stated that she would give the team members a list of terms and words that are used supposedly by gang members of YSL to show violence is about to occur. We do not have those terms or words. It was not on the video and it was not in any discovery. In order to challenge the wiretap, because there's a minimization requirement and the wiretap is not all encompassing, it's just for RICO, which by the way is not defined in the wiretap. So that's just like saying attempt or conspiracy. And then there was murder and criminal street gang activity. But I would like to know how to go through the wiretap, and others would like to know, and what are those keywords or phrases that were told are triggers that then the minimization requirement may be put aside so this honorable court can wrestle with it. So I want to particularize and help particularize the wiretap motion.
Okay, that was 23 March of this year?
Right, 22 March of this year. March 3rd of this year. I'm confusing myself. March 3rd of 2022.
Okay.
Yes, that's what it is.
All right.
So I want those words and terms. They can be given to me, on the record, off the record. I'll share it or in an email, but I need that to make sure that we don't miss something on the wiretap information. Thank you.
All right. Ms. Lowe?
Thank you, Judge. And just briefly, Your Honor, of course, the court's aware that we have turned over the wiretap. And to the extent that Mr. Steele referenced a challenge to the wiretap, we would argue that Mr. Steele does not have standing, Mr. Williams does not have standing to argue or to challenge that. But to the extent that he is also arguing with respect to being able to navigate the wiretap, we do not have a list of terms or words. I can tell the court that there were debriefings, there were meetings between investigators in the case as it was being prepared, and there have been meetings between the prosecution team and investigator Viverito, wherein we've talked and we've strategized and we've put things up on the wall. But to the extent that Mr. Steele and Mr. Williams seeks a written out list of words, that doesn't exist. We do not have that. And having worked with investigator Viverito for years, I know that the the way that she generally provides things to the listeners is she tells them, and we feverishly write things down. But we have provided her contact information to counsels for the defendant, and they see her here in court as witnesses, and so they are welcome to ask and inquire of her whatever it is that they choose or want to inquire of her. We do not have this item in section 2 of Defendant Williams' motion in limine.
Okay. Mr. Steele, is it you and your colleagues' intent to interview Ms. Viverito prior to trial on this issue?
We interview every witness. We try to interview every.
Sure you do. Okay. Have you attempted to interview her as of yet?
No, not on this. I would think that this is covered by the statute. It was mentioned in the debriefing that this would be told to the prosecution team for the express understanding of what the rules of the wiretap are to the prosecution team. I believe that we're entitled to that and challenge it. And I do understand Mr. Williams may not have standing, but I'm still a capable person. I'm trying to help the lawyers. And they're, well, you know, on the wiretap issue, it affects Mr. Williams because of the conspiracy count.
Well, to the extent that there is standing on other people, Ms. Love, is there some type of debrief or notes that come from Ms. Viverito on this issue? Or is it just all oral with you all taking down notes?
Your Honor, let me be really clear. I attempted to make plain that if we have notes from any investigator that regardless of standing to challenge the wiretap, we have an obligation to, and we will fulfill all of our obligations to turn those over. And that is why I said, we don't have a list of terms. We've talked to Investigator Viverito. We talked to her and we asked her, what do we look for? How do we do this? But we do not have a list as Mr. Steele has labeled it in his motion in limine. We do not have that which he is asking for. And
is there a debrief that's been reduced to writing?
No.
Okay.
It's on video.
It's on video?
Yes.
Well, he has it.
From the discovery on March 3rd, 2022,
So
video
we don't know.
recorded that I listened to, and it says, I will tell you these terms, because they have to look for the terms. People involved in this case who are listening to the wiretap live, they don't know about the case they're learning about, so they're being taught the tools and the rules of what to look for. We're challenging that. Someone's going to challenge it. Your Honor, of course, going to make a ruling on that. But I'd like to know what the words are that we told to them. If she states, Investigator Viverito states exactly what I said, I can give you, we can play it, it's not very long. You can play the recording, it's on.
Doesn't change things.
All right, well, if the state doesn't have that, how come you couldn't just interview her yourself and get that particular information?
How did the state?
They're telling you that they don't have those terms, okay?
They don't have a list of
They don't have a list of terms, but you have the video and you also have the ability to interview Investigator Viverito and and ask her questions about what you're asking this court as to at this point in time, and let her answer those questions fully to your satisfaction.
Well, I believe that the state is the obligation, but I will absolutely reach out to Investigator Viverito and take.
Okay, all right. Okay, let's move on to motion in limine number 20. That was 21, filed on 7/5. And I'll just put that back on for Mr. Steele for like the 5th of September. And we can kind of just discuss that at that point in time, okay?
Yeah.
All right. Motion limine number 22 is filed on 7/27 of 2023.
Your Honor, just a correction as we go through the list here. That last motion discussed was for discovery number 21. The next one up is 7-5.
Yes, sir. That was motion limine number 21. And there's motion for discovery number 21 filed on 6/28, and then motion limine number 21 filed on 7/5.
Which we still have yet to get to. Motion to eliminate 21 has not been reached.
Okay, 21 involves the jail calls. Motion limine 21, Mr. Steele.
Right. I'm just voicing ahead of time.
Is a foundation, more than anything else? I mean, it looks like recorded jail calls, conversations, speakers, confrontation clause issue. So I would think, and then potential hearsay, I would think that the state would have to have a good faith basis or an exception, and that would fall under foundation.
Okay, that's my motion.
Okay,
Thank you.
all right. Okay, I have motion limine number 22 filed on 7/27.
Okay, y'all. Did y'all fall asleep on me? Did I fall asleep on me? Hey, Tito. Okay. Let's Okay, hold on a second. I thought you guys fell asleep on me. Hold on. Don't know how much about court lore, but why does it feel like the judge is doing the best to be the That was a good one. That was a good one. Good observation. Good observation. All righty. Thank you, Stephanie, for the Cash App. Let me play my music for the Cash App. Hold on. Money, 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 so much money. Money, money. Thank you so much, Stephanie. Are you asleep? Everybody should be sleeping by now. Why you guys? Okay, hold on. I'm getting ready. Get ready to put the other half on there. Hold on, y'all. Hold on. Hold on. I still got more. Y'all thought I was sleeping, did y'all? Hold on a second. All right, here we go. 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 Gotta move it up a little bit. She ran to her. She said he stopped moving. Hold on. Here we go. Stephanie, why you not asleep? Go to bed. Go to bed, Steph. It's 7 in the morning there. Oh, Sean, it's morning time over there. Good morning. It's morning here too. Y'all like this, don't y'all?
So, Your Honor, there was a supposed killing of a gentleman named Mr. Drinks. It's Drinks. And there was an arrest. Mr. Williams is not, except for the conspiracy count, he's not involved with anything to do with that shooting of Mr. Drinks. But what happened was there was an arrest of Mr. Stillwell Jackson, and that's on March 17th of 2022. And I'm going to call it a religious ceremony he was in the middle of, and it gets graphic, Your Honor. There was supposedly an animal or animals that were being sacrificed, and on behalf of Mr. Williams, I'm going to ask the court to find that it has absolutely no relevance, the arrest or the circumstance of arrest, and it's Mr. Nichols as well, was arrested as well, to show the body cameras of law enforcement of this religious ceremony, unless Mr. Stillwell or Mr. Nichols or their counsel wants it to come in. Mr. Williams is making a strenuous objection. I believe that it will cause prejudice to jurors, how they look at certain people, and that I'm on a conspiracy count with them. And I believe that it is protected by religious freedoms, and that the court should exclude it. Not every circumstance of arrest is admissible in a case. It all falls under 403, 401, and 402. And in this case, 404A, because I believe it would be bad character evidence. Some people would think that that's bad character evidence. So I'd like it to be excluded.
Your Honor, on behalf of Mr. Stillwell, I am joining you on this motion. May I be heard briefly as well?
Sure.
Thank you. Your Honor, on behalf of Mr. Stillwell, just one minor dispute I have with Attorney Steele. I would not characterize the evidence as that Mr. Stillwell was taking part in any ceremony, but he was arrested in the middle of what appears to be a ceremony. Individuals, and there's discussion amongst the police officers that arrested Mr. Stillwell and Mr. Nichols, and that they're discussing it and somewhat amused by it. But there's everyone takes note of the fact that there was goat blood, etc., around and on people's hands and things of that nature. I believe that the state believes that Mr. Stillwell is associated in some way with the owners of that house and with those practices. Whether he is or not is completely irrelevant to this case. It doesn't even, beyond the possibilities of extreme prejudice and confusion of the issues and the like, it's completely irrelevant to this case. And so while I do not concede that Mr. Stillwell was actively involved in any ceremony, I do echo the concerns that his perceived association with these individuals practicing what I would say is their guaranteed First Amendment rights would potentially prejudice Mr. Stillwell. And for that reason, I join Mr. Steele in his motion.
Okay. All right, State, do you have any issues as to the circumstance of the arrest? Are you gonna try and get into that in any way? Ordinarily, they're not relevant, so.
If I could briefly go into that. The state at this time doesn't have any intention to explore that or, put up prejudicial evidence that's irrelevant. But I do want to point out a couple things to do with the nuts and bolts of what was just argued. First of all, Williams doesn't have standing to challenge the circumstances of Stillwell's arrest. Now, of course, Stillwell has, I guess, adopted that motion, but not in writing yet. So for the time being, you can't challenge the circumstances of someone else's arrest. Indeed, Williams isn't even challenging the validity of the arrest. And Stillwell's attorney just got up and said, oh yeah, they're not involved in the supposed religious
There's a
rights.
conspiracy aspect in the floor. There might be 404A issues in that respect. So So you ordinarily, the circumstances of one's arrest, I mean, people get arrested in all types of issues, so surrounding that, and I do have to apply a 403 balancing issue, so, but ordinarily the circumstances of one's arrest are not usually relevant, so, and there may be some minimal relevance depending upon whether or not evidence is presented or certain things are testified to, but as a whole, nobody should be testifying about, since this involves religious practices. And Mr. Stillwell's got standing. Now, but to the extent that it may, this particular incident may implicate others, I'll consider it for that reason.
Okay. And if I may, just, I'll point out one item of authority to do with circumstances of arrest. This is going to be Thrasher v. State for the court's consideration. It's 289 Georgia Appellate 399. It's at 400 and 401.
You said 289 what?
289 Georgia Appeals 399 at around 400 and 401, right at the end of 400, Your Honor. That's a 2008 case. And it's, I'll go ahead and say it's not to do with the type of rites and ceremonies at issue at this time, but it does say explicitly that, quote, all circumstances surrounding an arrest, which the validity of which is not challenged by either Williams or Stillwell here, all circumstances surrounding an arrest are admissible.
Well, Stillwell's challenging the fact that there may be a religious ceremony and that there may be a alleged sacrifice of a goat or animal. So he's challenging that.
Okay, I'll accept that challenge. So again, all circumstances surrounding an arrest are admissible for whatever value the jury desires to place on them. Where evidence may incidentally put character in issue or be prejudicial, it may be admitted if otherwise relevant. Now, of course, Your Honor, as I said, the state has no intention of introducing this. There's no need at this point, at this time. But should somehow it become relevant, we want the court to be apprised of the relevant law to do with circumstances of arrest. Again, the validity of the arrest is not contested. The circumstances and to what extent they're sort of tangentially admissible as part of the arrest being admitted, that's what's in dispute. But Thrasher v. State says it's a wide berth that you get when you get someone arrested, and you're going to talk about that arrest.
I'm not going to let you get into the to the religious ceremony or talking about what was allegedly done when the officers came. I will revisit so you can tell your witnesses that, because it does involve religious ceremony or whatever. It may otherwise be relevant for other purposes. I'll take those up should the circumstances exist. Okay.
Thank you, Your Honor. That's
all right. So, Mr. Sharp, if you prepare a suitable order for my signature, send that to your colleagues, Mr. Uhelski and et al. I'll take a look at it. If you get that done by the 6th of
by virtue of the rule that we had earlier, of course, Mr. Nichols does have standing down.
Yes, he would. All right. So you let Mr. Harvey weigh, or Ms. Westmoreland, or weigh in on that as well, okay?
Guidance, Your Honor, based on
404A and 403.
No, they didn't talk about the speedy trial.
Your Honor, I just wanted
the
to
speedy
clarify,
trial,
again,
oblivious. Hold on. The only thing the judge says for them to
tag teaming them. So it's usually one attorney per argument.
Your Honor, I'm
gonna cut you some slack. All right, but go ahead, finish up. What does he want to invite my attention to?
I just wanted to reiterate Mr. Uhelski's representation. We do not foresee, and did not at the time that we read the motion, we did not foresee any circumstance under which we would be attempting to introduce any goat sacrificing ceremony information, Your Honor. But my understanding from the court's ruling, I just wanted to clarify, was Your Honor stating that should there appear circumstances that the state wanted to bring to the court and to the counsel for defendant's attention, that the court would hear those requests.
But there's still ways to get. I'm just giving you hypothetically. Okay, say there's an issue of presence, and there's some testimony that might be offered as to that, or alibi or whatever. I mean, it could be that, you know, then this,
Right.
you know, at least the circumstances of you being at a location might be relevant, but still, that whole issue of what they were doing is not really relevant. It's not. I mean, because it's more prejudicial than anything else. So no matter what was going on at that point in time is not really relevant for the inquiry of most things. It's just highly prejudicial. Most people would probably think that, you know, goat sacrificing and everything is probably not really a good thing. So I think that it does have the ability to introduce bad character. So for those reasons, I'll go ahead and I'm not going to allow that at this point in time. I'll revisit it should there be some issue as to, and I'll revisit at that point.
Ray, I had
We'll make certain that we instruct all of our
yes.
Thank you.
What I'm gonna do is put my link in there, Ray.
Motion
I
limit
had
number
somebody who
23,
came up to explain
filed on
that whole Valley,
7/27.
that whole religion thing.
And I want to say this
I'm gonna
is
put it in my
Wiretap,
link in there.
calls 1205 and 1273. Is that correct, Mr. Steele?
Yes, sir.
Mr. Steele? Okay.
So when I was listening to the wiretaps recordings, it's Mr. DG's phone that is targeted on the wiretap, and he's supposedly speaking with Mr. Stillwell. And they're speaking about Mr. Stillwell is charged with murder and of Mr. Drinks, and was considering hiring me. And they talked about the fact I will not represent Mr. Stillwell in the case. I was not retained. I was never retained on the case at all. And I just want, like I said earlier, and the court already ordered, I just don't want my name I don't want that to be played. I don't want my name to be brought up as somebody Mr. Stillwell wanted to hire unless the state first proves that it's relevant and necessary in the case. And I know you ordered that previously, but when I heard the wiretap information.
There it is right there, Ray. Just click that link. That's the link that's gonna explain to you that whole religion thing.
I'm sorry.
It's not Satan worship.
About that issue in regards to Mr. Steele.
Well, we want to clarify to do with like these calls, 1205, 1273.
They explained
one
it.
of
The
them's
guy
11
explained
minutes,
everything
the
in
other's
regard
5
to that
minutes.
religion.
We do have those for the court to consider at the appropriate time, but I just want to outline something to do with this motion that.
You know, Ray, I do my homework, so I try to
states
bring things
fraud a
up
little
so
bit.
people.
The motion
I
is to do
love
with
knowledge.
removing all
I'm
mention
sorry,
of
hold on.
Mr. Steele.
I love
from
knowledge,
these
so I like
calls, should they be
to
played.
educate folks on things that
But
they
then,
don't know
by the
about.
time you get to the end of this motion, Mr. Steele is asking for this
Knowledge
evidence
is
to be
power.
excluded
That's
in
what they
toto.
say.
So he's saying that because he may have been mentioned in the course of a 5-10 minute conversation.
What's the relevance of Mr. Steele? I mean, that's really, at the end of the day, what's the relevance of including him?
Well, the inclusion of Mr. Steele is not what worries the state.
Oh, then a suggestion I might have for you, if you believe the rest of the call is relevant, you can lay a foundation, just edit it. I mean, if you've got no reason to have Mr. Steele as part of that conversation and you have other relevant information, then appropriately, redact it or whatever and for everyone's consideration.
Your Honor, also.
Same objection, one attorney per motion.
Yeah, come on now, Ms. Love. I mean,
You
Ms.
keep
Love,
doing it.
That is becoming an issue for me. Really, one of you is supposed to argue, not, Mr. Steele and Mr. Adams aren't doing that, and the other lawyers that have other two lawyers, it's one examiner or one person responding for that. Okay?
Yes, Your Honor. Could the court allow us one moment? Mr. Uhelski.
Yes, ma'am.
Thank you.
Poor guy. She kept doing it. I mean, if she don't trust his judgment, why put him up there? Why don't she just do it? That makes him feel bad. I mean, you got to add on stuff while he's talking.
Your Honor, to your point, what it would go to relevant wise, it would, first of all, remembering motion in limine number 1 that we heard last week, the relation to the parties and the parties' counsels, and then number 2, the ongoing conspiracy. Just because the defendant is maybe incarcerated or arrested, that doesn't mean that the conspiracy is terminated. There's a concealment phase, and there's a, in furtherance, statements made in furtherance of a conspiracy where.
I got all that, but what's Mr. Steele have to do with any of that?
The idea is that we have.
He's not part of the conspiracy. You haven't charged him as part of that. He's not, I mean, I don't see anything that would, where you're indicating that he has done something that allegedly would.
It would go, Your Honor, to the willingness of one co-conspirator to another to help aid and secure legal counsel for the crimes charged in this conspiracy. And whether it's Mr. Steele or otherwise, the fact that they're continuing to speak with one another in furtherance of these conspiratorial objectives, we would argue that that's absolutely relevant. And that's co-conspirator hearsay. That's admissible. And
Okay, I get it, but not as to Mr. Steele. I'm just not going to let you get into that. I'm sorry. You can edit it and you can take him out, but I'm not going to let you leave him in there, okay? That's not really relevant. It's more prejudicial and probative.
Final word on this. It is going to be part of our theory that Jeffrey Williams is willing to procure counsel for his co-conspirators. And there's going to be other evidence to corroborate that. But this is part of the tapestry. And these conversations, mentioning, we're going to, for instance, the call talks about, for instance, Stillwell had just been arrested. That's an update on the status of the conspiracy. And then, is Stillwell going to be able to get an attorney and representation? And then nobody, Mr. Steele happens to be referenced in there. But it basically goes to, the conspiratorial objectives. And
So hiring counsel, you're saying is, or conspiratorial objective, is that what you're alleging?
Well, if you have someone who's alleged to be the head of a conspiracy and they're offering to procure legal counsel for the other alleged co-conspirators, then the answer yes. The answer is yes. Their songs include him, Your Honor. It's not. I understand that it's maybe distasteful that there are going to be conversations that mention him, but those conversations took place, and if those conversations are in furtherance of the conspiracy, we can't just edit them to take away unsavory details that are kind of just not convenient, but there's really no.
Tell you what, I'm going to defer ruling on that one. I want a written brief on that issue. I want you to write a brief in response to that issue. So
that's agreeable. Thank you, Judge.
All right, and if you could have something to me. Tell you what, Mr. Steele, you want to augment anything in regards to that in writing?
Sure, I'll reply.
Okay, all right. Let's just say if you could have something filed by the 5th, and then Mr. Steele, if you could just file a response by the 10th, that would be fine. I'm gonna take that one under advisement. I need to think about that a little bit more.
Thank you, Your Honor.
Okay.
Excuse me, Judge, can we take a break?
Sure. Let's do a comfort break, and then I've got about 3 or 4 things to do, and then more things to take up, and then we can take lunch. Okay. All right. So we'll be in recess for about 5 minutes.
Are you guys sleeping? Hey, Jake. It's a long video. I'll watch. You have a good night. Exactly, Bobby. Oh yeah, I'm about to end this, and you guys, we can continue tomorrow. Let me just end this from where we are at right now, and we can continue this coverage for tomorrow. So, what do you guys think? What are some of your thoughts on what we just watched? What are some of your thoughts on it? Okay, I do have the video of this whole so-called ritual that happened, and it didn't happen the way. Did you guys see that video? Did you guys see the video with the body cam? Did you guys see it? Would you like to see, would you like me to play that video for you guys so you can to me, the defense is making lots of excuses. You said the defense is making a lot of excuses? I'm not understanding the question. I mean, the statement. You said they're making a lot of excuses to what? To what? What are they making excuses to? Not being prepared. Who? You said the defense is making excuses for not being prepared? You remember a lot of the stuff they still don't have. A lot of the discovery they still do not have. They're trying to make sure that everything is given to them. He put a whole bunch of emotions for discovery that were not provided to them, and when they provided to them, there was one time the stuff with the disc was empty, didn't have anything in it, and then there was another time they couldn't open up the disc, so they had to reformat it and all. They have to reformat it. And what Steele is asking for is like, okay, they have stuff that's hidden, like they don't label it correct. Like, okay, do you remember when Max said something about that they have a video of somebody, well, it may not be the person, but then they label it as Dorsey, and it's not, it's not that person. So a lot of stuff is very ambiguous. It's like, it's not matching, and then they don't want any surprises of when it comes out, and then they have to put the jury out, and then they have to go through stuff that's supposed to have been in there. They're just trying to make sure everything is up and up, and there's nothing being hidden. And it's not just one attorney; it's most of them are saying that because they've been having problems trying to get into the discovery. There's a lot of stuff, even with when they were talking about. Remember the lady who said she was a gang expert? Well, she says there's terms that she has that she's supposed to give to them, and she still has not given it to them. So then the state is saying basically, oh, we don't have it either, we don't know. So then the judge is saying that, hey, you can interview that supposedly expert and talk to her about it, what you need, so everything's not provided. So there's some lack going on, and Steele is very thorough. He's very detailed. He just want to make sure that everything is there. There'll be no surprises, so he can handle everything regardless of what it is. And so they don't want anything hidden, like mislabeling certain things, and then all of a sudden they pop up with it, and they're thinking that it's one thing and it's not. That's what they're talking about. So they want to make sure by the time this trial starts. Do you remember last year when the state was asking for more time, and the judge denied them because of the speedy trial? And it seemed like they end up getting more time because what they're doing is building a case, and because they didn't have all the information, they didn't have all the stuff that is supposed to be, supposedly have. they indicted, and then now they're trying to scramble to put things together, and then there's things that's not in order, and so the attorneys are just like, we're not going to be caught with our pants down. That's just a terminology, but they want to make sure every T is crossed and every I is dotted, that the government don't sneak and have something in there they don't know. So they're reviewing everything very slowly and making sure everything is what everything's supposed to be. So that's what's happening. It's very tedious, but they want to make sure. I think it's a very good thing, especially if you're a defendant. You want to make sure your attorney got everything that they're supposed to have, and that's why the judge had ruled for the defense to be able to look at the discovery. You know what? I'm going to show you guys. Okay, hold on. I know I'm supposed to be going to bed, but you know what? I like showing stuff. Okay, let me show y'all something. Hold on. This is why the judge allowed the individuals to sit there and have the discovery, because half of the stuff that they're bringing, the lawyers don't know some of this stuff, and the defense can explain it to the lawyer, and the judge did rule on them for them to be able to look at the discovery stuff on the computers and on the laptop. But Eppingers went in, started having conversation with that officer, and so he messed up the stuff that he was supposed to be doing. Okay, hold on. I'm trying to open it up for you. Okay. Let me get this. Okay. Okay. Okay, this is the court order that the judge did for them to be able to look at this stuff. Hold on a second. Hold on. I'm just going to present it for you guys. Okay, this is the court order that the judge originally gave for them. It says here, this is just Quintavious Greer. I happen to have that one. Order allowing defense counsel to bring electronic into the Fulton County Jail, right? The court having considered defendant motion to permit electronics and permit use of cellular devices in jail for the purpose of reviewing discovery with defendant Greer and preparing for trial, and having heard arguments on behalf of both parties, defendant's motion is hereby granted as outlined below. It says it is hereby ordered that the defense counsel, Nicole, whatever her name is, blah, 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 as well member of her staff, may bring laptop computers and single phone hotspot device that is not a cellular phone in the Fulton County Jail during the visit with defendant Greer, subject to the following. One, attorney will use a single mobile hotspot device to create an internet connection so that the discovery document produced by the state by a cloud document shared can be accessed for view. Two, with the exception of a single mobile hotspot device, any and all cellular devices with hotspot capability, which include but not limited to cell phone, are prohibited from being taken inside, right? Three, counsel shall take all devices with them when they finish their visit and shall not leave any electronic device with defendant Greer. Four, no outgoing calls to any third party are permitted. 5, counsel shall comply with all previous orders of the court pertaining to disclosure of discovery material and attorney's information. 6, violation of this order shall subject defendant and defense counsel and staff to sanction, including but not limited to contempt of court, reporting to State Bar of Georgia, and any further action court deems appropriate. Okay, so there was an order for them to be able to bring it inside the jail, and also there's an order for them to be able to use it in the courtroom. So, all right, I'm about to go to bed because I keep yawning. So, good night, good people. Thank you so much. And tomorrow we'll come back for a second half of our education. Because, you know, I like to give you guys information and provide information so you guys can be educated and don't go by emotion, but by what is written down and some facts. All right. So, yeah, I'm about, look, grand jurors, I'm so sleepy right now. Good night, Steph. Steph, why you up? You need to go to bed, young lady. You got to get up and go to work. I got to get up too. I don't know why I'm still up. But I just love when I get stuck inside of doing stuff like this. I love it. Good night, good people. Have a great night.